Hey guys, welcome back to the channel where we break down complex legal topics into simple, digestible pieces. In today's video, we will be talking about an essential document that every company in Singapore needs, the company's constitution. The company's constitution is a formal document that sets out the rules governing how a company operates. Think of it as a company's rulebook. It outlines key matters such as the rights of the shareholders, how directors are to be appointed and removed, how shareholders' meetings are to be conducted. In Singapore, under the Companies Act, every company must have a constitution. This is mandatory whether you're setting up a private limited company or a public company. So why is the company's constitution so important? Well, it serves as a legal foundation for the company's governance. It ensures that everyone involved knows the rules and what is expected of them. More importantly, the Constitution safeguards the rights of shareholders and helps manage the relationship between them and the company's directors. For example, it can include provisions on dividend distribution, voting rights, and even how disputes are resolved. Without a constitution, a company would lack the necessary framework to function effectively and fairly. And here's something interesting. The constitution is not just a set of rules, it's also a contract. According to the Singapore Companies Act, the constitution is a binding contract between the company and its members or the shareholders, as well as between the shareholders themselves. This means that the provisions in the constitution must be respected and followed by both the company and its shareholders. Any breach of these provisions can lead to legal consequences, and it also governs how disputes between shareholders are resolved. Under the Companies Act, every company, whether new or existing, must have a constitution. If you are forming a new company, the process of adopting a constitution happens at the time of incorporation. For companies that existed before the current rules, their memorandum and articles of association are now treated as a company's constitution. In short, every company needs a constitution. It's not optional. Without one, your company would be in breach of the law. Now, where can you get a constitution? For newly incorporated companies, there's good news. You don't have to draft your own constitution from scratch. The Accounting and Corporate Regulatory Authority, known as ACRA, provides a standard model constitution that can be adopted during the incorporation process. Of course, if you have specific needs, you can always customize the constitution to suit your company's unique requirements. It is a good idea to consult a corporate lawyer if you need help drafting or modifying your constitution to ensure that it meets all legal and commercial considerations. Now, what happens if the company or its shareholders breach the constitution? Since it's a binding contract, any breach can lead to legal action. For example, if the directors of a company make decisions that violate the constitution, shareholders can potentially take them to court. Depending on the severity of the breach, the court may order that the decision be reversed or damages to be paid, or even that the company be wound up. In extreme cases. Winding up means closing down the company. It is therefore crucial for all parties to understand and abide by the Constitution to avoid such costly disputes. In summary, the company's constitution is not just a legal formality. It's the backbone of a company's governance and operations. It serves as a contract between the company and its shareholders, ensuring that everyone plays by the rules. Every company in Singapore must have one, and breaching the constitution can lead to serious consequences. Thanks for watching, and if you found this video helpful, don't forget to like, subscribe for more legal tips and insights. See you in the next video.